This is Barry Zalma speaking for Claim School Incorporated's Zalma on Insurance, a blog. Today I'd like to speak about a case that established in Montana that no good deed goes unpunished, and that eliminating one piece of evidence did not deprive the plaintiff of her right to present her case. After reaching a settlement of multiple claims presented against her insurer, that was also the insurer of a third party, Connie Humes sued for bad faith and violation of the Unfair Trade Practices Act, the UTPA. Humes appealed trial rulings by the trial court, excluding evidence of certain settlement amounts paid by Farmers Insurance Group in a trial of her injury claims. In Connie Humes versus Farmers et al., the Supreme Court of Montana on July 26, 2022 resolved the dispute between Ms. Humes and Farmers. The issue before the Supreme Court was, did the district court abuse its discretion by excluding evidence of settlement amounts paid in a global settlement of multiple claims by Farmers Insurance Group in a subsequent trial under the UTPA. The factual background of the case included the fact that Barney Bankelman rear-ended Humes' vehicle at a stoplight in Helena, Montana, causing injury to Humes. Bankelman was covered by Farmers Insurance Exchange for bodily injury liability. Humes was insured by Mid-Century Insurance Company, including underinsured motorist coverage with a $250,000 limit and medical payment coverage with a $50,000 limit. Farmers considered the accident a dual insured loss, which occurs when parties involved in the accident are insured by the same company. Humes retained counsel and made first-party UIM and MedPay claims under her Mid-Century policy. Mid-Century requested Humes undergo another medical examination and subsequently denied continuing MedPay benefits. Humes then filed suit stating claims against Bankelman for negligence and against Mid-Century for breach of contract for denying UIM coverage claims, breach of contract for denying MedPay coverage, and breach of the implied covenant of good faith and fair dealing for alleged mishandling of her first-party claims. The insurer offered Humes $40,000 to settle the Bankelman claim. Humes declined the offer, and thereafter all parties participated in a global mediation session. During the mediation, Farmers and Humes settled the Bankelman claim for the policy limit of $100,000. About 48 hours thereafter, Humes and Farmers settled Humes' claims against Mid-Century for a payment of $220,000, $200,000 under the UIM policy and $20,000 under the MedPay policy. Thus, all four of Humes' claims in the underlying action were settled for payments of totaling $320,000. Humes then sued Mid-Century and FIE, respectively, for alleged violations of the UTPA, a Montana statute. In its trial memorandum filed less than a month before trial, Farmers asserted for the first time it had paid a portion of the settlement to Humes in the underlying action with funds from its SAE group, a department assigned to handle bad faith claims. Farmers stated it should be allowed to present evidence that its bad faith department paid an additional $50,000 on top of UIM and medical payment settlements in the underlying settlement. Farmers argued that Humes was attempting to use the final settlement amount as proof of Farmers' valuing her injuries at $320,000, and there was no foundation for that. They They want the jury to assume that because farmers paid $320 to resolve multiple claims, that is an absolute slam dunk admission that the earlier offers for her injury damages were too low. Consequently, Humes was prohibited only from stating the specific amounts of the settlement under her mid-century coverage and the total farmers had paid to settle all 4 claims. Following a 5-day trial, the jury determined FIE and mid-century did not violate the UTPA and that the insurance companies had a reasonable basis in law or fact for their conduct while negotiating Humes' claim. Humes argued the district court's exclusion of the specific settlement values prevented her from showing the degree to which farmers intentionally undervalued her claim against Benkelman, and thus from proving her case under the UTPA. The difficulty with Humes' argument is that farmers did not pay $320,000 to settle the exact same claim for which it initially offered $40,000, nor, as further argued in her briefing, was farmers' ultimate settlement 8 times the value of its offer going into mediation. Humes' arguments are internally inconsistent. Farmers ultimately paid $100,000 to settle the exact same claim, and the district court permitted Humes to present these specific amounts to the jury. The relevance of the settlement amounts excluded by the district court were debatable. The use of the $320,000 aggregate value as proposed by Humes was to prove the value of one claim, when to the contrary, this amount settled 4 claims. A trial court may exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. Unfair prejudice may arise from evidence that confuses or misleads the trier of fact or unduly distracts the jury from the main issue. Contrary to her argument, Humes was given broad leeway to present significant evidence in support of her allegations of improper claims handling by farmers. Humes introduced evidence of the short period of time between farmers settling the Benkelman claim and then settling the mid-century claims multiple times, and she argued this demonstrated improper leveraging by farmers. Humes presented correspondence showing Hunt, the adjuster, had authority to settle for policy limits within a week after Fox demanded it, but instead gave farmers' attorneys permission to offer only $40,000. Humes' expert attorney, John Morrison, when asked about Hunt's $40,000 offer, commented that it was only a month or a month and a half later that farmers comes in and pays not only the full policy limits, but significantly more than that. The testimony from Fox and Morrison clearly supported Humes' theories that farmers leveraged and undervalued the Benkelman claim. Humes was clearly able to present factual evidence and expert testimony supporting her argument that farmers failed to promptly settle the Benkelman claim in order to influence settlements under her UIM policy in violation of the UTPA. Farmers presented evidence to support its defenses that its adjusters had a reasonable basis for disputing the causation and severity of Humes' injuries, and that liability in excess of policy limits for the Benkelman claim was not reasonably clear, justifying the delay in both third and first party settlements. An insurer may not be held liable under this section if the insurer had a reasonable basis in law or in fact for contesting the claim or the amount of the claim, whichever is in issue. The jury received this evidence, including almost 3 days of testimony in Humes' case in chief, and ultimately found farmers' adjusters had acted reasonably. In addition, Humes introduced medical evaluations and examined adjusters about why they had disputed her injuries, introduced early settlement demands from Fox and challenges adjusters on why they rejected those demands, and used claims files and employee correspondence to confront adjusters about their evaluation process. The Supreme Court concluded that it could not fault the district court's determination that Humes was not prevented from putting on evidence supporting her theories regarding how the insurers valued her claim. Rather, the order at issue only prevented Humes from using one piece of evidence, the settlement amount, and its omission did nothing to prejudice her case. The Supreme Court concluded that the district court did not abuse its discretion in its evidentiary rulings for the same reasons it likewise did not abuse its discretion in denying Humes' motion for a new trial. Considering the evidence Humes was able to present, the district court's denial was not so significant as to materially affect her substantial rights. In my opinion, some people cannot be satisfied even with the settlement of a lawsuit, and when they get what they ask for and enter into a formal settlement with the assistance of a mediator, they want more. Filing a second lawsuit under the UTPA and then attempting to bring into evidence the original settlement amount as if it was only paid for her injuries, when the insurer's evidence showed it included bad faith damages paid from a special fund maintained by the insurer, Mrs. Humes, was simply not satisfied with the litigation and settlement she reached, and had to try for more. Even though farmers folded and paid what she asked at mediation, she sought more, and the jury in the Montana Supreme Court refused to allow her to profit from her accident. This video was adapted from my blog post at www.zalma.com/blog, and you can subscribe to the blog and reach the blog every day in your email. Thank you for your attention.